Welcome, everyone. We're going to get started in a few moments. Okay, welcome, everybody. I think we have some people already logged in, ready to go here. First of all, thank you for joining us this evening. My name is Joanne, and I will be your moderator. Before we begin the presentation, I'd like to go over just a few housekeeping items. We are recording this webinar, and a copy of the recording will be emailed to you within the next 24 hours, along with a copy of the slides after the presentation. You do not need to turn your webcam on, and everyone has automatically been muted at the beginning of this webinar. If you need to ask any questions throughout the presentation, feel free to use the chat panel on the side, and we'll make sure by the end that everybody has their questions answered, and we can discuss any last-minute questions at the end as a group. If you have any technical or audio difficulties, please close the webinar and log back in. Sometimes that gets the system going again. And now I'll turn it over to Alyssa to start the presentation.
All right, thanks everybody. Thanks for joining us. My name is Alyssa. I'm an attorney with the Monteleone Law Group. I specialize in all of our matters with our clients pertaining to estate planning and elder law. The reason behind this webinar this evening is to talk about estate planning. A lot of it is in general, but a lot of it also is geared toward specific issues that have been popping up because of the COVID-19 outbreak that we've all been going through. In the past month, our lives have really been turned upside down, and the way that we live our day-to-day lives has completely been changed. And I think the most unsettling part about all of this is that we are really out of control of most of this. We can't control who this affects. We can't control whether other people are abiding by the social distancing guidelines. We really can't control when this is going to end. The only thing that we control is ourselves and our own lives. And I have had a handful of clients that have been directly affected by this situation. Either they have themselves have gotten it, and so I've lost a few clients. I've had some clients that have lost their loved ones, and it's a really heartbreaking and devastating situation to have to walk through with these clients. But I can say from experience that one thing that's kind of like been the silver lining through all of this is my clients have their estate plan with all of the very difficult decisions already made. So their loved ones are really able to just execute the plan and do what needs to be done to make sure that mom or dad are protected, that they're protected, or any of their loved ones that are included in this plan are protective. So what I've taken away in the midst of all this is that really we are in control of ourselves. And the way that we remain in control is by being able to make these choices and putting them into our estate plan. So if there was a sudden or unexpected illness or death, that really everyone knows what to do. And there's really no question about that. So these choices will provide a lot of peace of mind to our loved ones. So we're going to jump into the webinar now. Before we go any further, I do need to say that this webinar is for informational purposes only. Do not rely on this for legal advice. If you want legal advice, then we can definitely talk about that offline in a consultation. But this is more for a general educational purposes. I practice in New York and I practice in Virginia also, so I know that I have attendees from both places on with us tonight. Almost all of this is applicable to both Virginia and New York. We just may call some documents different things, and I will let you guys know if something is called something different in Virginia or New York, but it's pretty much the same as we go. All right, so I lost my, here we go. All right, so tonight we're going to be talking about a few different topics. The first is healthcare decisions, what's involved in making our healthcare decisions if we're unable to speak for ourselves. The second is our financial decisions, and then we'll talk about what happens to our stuff later on after we pass away and how do I make sure that that's taken care of. And the your kids out. So we'll start with our healthcare decisions. So step one, whenever I'm working with clients, that's one of the first things that I talk about with them is let's talk about putting together a healthcare proxy and your living will, or if we're in Virginia, these two documents get smushed together and they're called an advance directive. A healthcare proxy is a document that allows you to appoint an agent to make medical decisions for yourself. So if you know that you have a trusted person in your life, maybe it's your spouse, maybe it's your child, maybe it's someone else, that you know that when the time comes that they are the one that you trust to decide what happens regarding your health if you're unable to speak for yourself, then you would put this in your healthcare proxy. The second document that works in conjunction with this is your living will. And that's the document where you would outline what type of decisions can your agent make for you. So you would be able to tell them, you know, hey, I'm okay with treatments like a life prolonging medical treatment, like a ventilator, a feeding tube, or I want artificial nutrition. I want food and water through an IV. You know, some people say, hey, I want you to keep me alive as long as possible. Or other people say, no, I don't want any of those measures. I just want pain medicine. I want to be made comfortable and I want to pass peacefully. And these are the documents where you would be able to outline that for your agent to make sure that these things are carried out on your behalf. So before we go any further, I'm going to put up a polling question because I'd like to get everyone's thoughts about this, or even I want to see where everyone is at with this. So there should be a polling question that is going to pop up on your screen now. This isn't anonymous. We won't see what everyone answers. But if you were to end up in a hospital tomorrow, would your loved ones know what type of medical treatment you wanted? So you'll be able to select yes or no, and then we will see how everyone voted. I'm going to give you another couple seconds. Okay. All right, so it looks like 80 of us said no, 80% said no, and 20% said yes. So this is definitely a reason why estate planning is important, because you at least need to put down in writing for somebody to know what you want in the event of an emergency. Or if you ended up in the hospital and an important decision needed to be made about a specific treatment, a specific surgery. I know a lot of people, I just got off the phone with a client who said, my mom's in the hospital, she has COVID-19, and now her spleen is inflamed, and they're consulting me on whether we can do surgery, what, you know, and it kind of ends up being a domino effect when you're in this situation. And it's important for your loved ones to know what you want, because on top of all of this in these situations, having to make these decisions and then worrying about is that what mom would have wanted? Is that what my dad would have wanted? It just adds an extra layer of so much worry and anxiety that if your loved ones knew what you wanted, it would just make this a difficult situation that much easier. So it's very important to figure out what you want and who you want to allow to make these decisions on your behalf. So some decisions that a healthcare proxy can make for you. This is important because I counsel all my clients. We talk about what their wishes are, and we add this to their documents. So you would be able to outline whether your healthcare proxy can authorize treatments to prolong your life, a ventilator, a feeding tube, CPR, a do not resuscitate order. Those are all part of your healthcare proxy. Whether they can authorize risky treatments. Sometimes people, one of the big questions is, do you want to be part of a drug trial? That's something that your healthcare proxy can, one of the decisions they can make. Can they take you off life support? Can they confer with family members, or even making decisions based on your religious beliefs? And another very important and very hot topic in this area now is they can decide who can visit you in the hospital, when you're at home, and that's a very touchy subject. So you want someone who's going to consider your wishes when they're in control of what's going to happen to you. A lot of times I get the question of, oh, I get a call that says mom doesn't have a healthcare proxy and now mom has dementia. Can we make a healthcare proxy? The answer is no. You have to have capacity to make these documents, meaning you have to know what you're doing and understand the consequences of the decisions you're making. And if you aren't able to, then we can't execute these documents. And oftentimes clients don't have them, so they can't appoint a specific person. So How this works is Virginia and New York allow an order of priority for individuals to step in when there is no agent appointed. So generally the order is your spouse, or in New York, your domestic partner. Then it would go down, if there's no spouse or domestic partner, it'd be your adult children. And the issue there is, what if they don't agree? What if some kids want to keep mom alive? And what if other kids, they say, hey, I want that inheritance, so let's pull the plug. I see that often. Then let's say your parents are still living, they would be next, your adult siblings, and or a close friend is the last person. So this is important to think about. If you don't have a healthcare proxy, the state will come and say, hey, we have a plan for you. And a lot of times this is not what someone wants. You know, maybe I don't want my spouse making my decisions. Maybe we have a contentious relationship. Maybe I trust some of my kids, but not all of my kids. And a lot of times, maybe my kids don't know my medical history, so they don't have really the knowledge to make these decisions, or they might find something out about me that I don't want them to know. So it's important to make sure that you have the right people in place. And the biggest thing is, who can be your healthcare proxy? Picking these people to be your to rely on to be your agents is a huge decision. You need to make sure you have the right people in place, and you can pick almost whoever you want, but there's some things that you should consider. And I would definitely say that you also need to be having conversations with people that you have in mind. If you want your daughter to be your healthcare proxy, you really should talk to her before you appoint her and not surprise her when the time comes for her to make these decisions, because they need to make sure that they know what you want, and also that they're comfortable in that role, because these are very tough decisions. So your healthcare proxy has to be 18 or over, someone that is willing to take on the role, and someone that you can trust to make these decisions in your best interest and according to your wishes. I know that if it was up to me and I had to make the decision of whether to take one of my parents off life support, the struggle that I would have, or some other clients' children have, is, how do I get over that emotional issue where I don't want to take my mom or dad off life support, but that's what they want. They don't want to live that quality of life on a ventilator. So you have to make sure that that person is able to kind of get over the emotional part of it and make sure they're doing what you want, because that's ultimately what their job is. They're going to step into your shoes and make the decisions that you would make for yourself, but you're unable to. So it's important to make sure that you have the right people in these roles. The second step in an estate plan is to make a HIPAA authorization. So as many people know, getting information from a doctor's office or a hospital is extremely frustrating and difficult. HIPAA requirements prevent doctors or any medical professional from giving any information out without an express authorization to release that information. So this is a very simple document that goes a long way, because if I could tell in my healthcare proxy, appoint an agent to make decisions on my behalf, but they can't get access to my medical information, then what good is any of that? So when I'm working with clients, we are definitely making sure that we have all bases covered, and that we're putting together a HIPAA authorization to allow that agent to get the information that they need to make these decisions. So this is a crucial document. It's such a simple document to do, but it's like it makes or break your plan regarding your medical decisions. All right, so that's basically an overview of healthcare decisions that need to be made, and we're going to jump into financial decisions. And this is another very big, important topic because everyone has some asset or a bank account or something that needs to be managed on a regular basis, or some bill that needs to be paid. So if you're unable to manage your finances or go to the bank for yourself, someone needs to do that on your behalf. And how they do that is through a power of attorney. So as part of the estate plan, I would say step 3 in all of this would be to review or create your power of attorney. And the power of attorney is crucial in any emergency situation, whether you end up in the hospital or you're homebound and can't go to the bank. Or a lot of times I deal with power of attorneys when I'm working with clients to get benefits through Medicaid. And people have assets that need to be protected, and mom can't do it for herself because she has a memory issue. So son or daughter step in and rely on her power of attorney, and now they're able to shield all of her assets from having to be spent down. So this document is crucial in an emergency. It's also very important to make sure that you're naming the right person as your agent and that they're a trustworthy trustworthy agent, because they're going to be able to really do almost anything with your finances if you allow them to on your behalf. So they'll be able to get access to your bank accounts and move money around and possibly make gifts if they have to, and they can pay your bills and sell your house and move money to your trust, and they can update your beneficiary designation forms. And those are big, huge financial moves that they can make, and you need to make sure that the right person is in charge of all this if you're unable to do it for yourself. And the issue becomes, if you're unable to do it for yourself, there's not a lot of policing that's going on. So a lot of times what happens is, if the wrong person is involved, we don't know until after the money's all gone. I have a number of clients that will call me and say, "Oh, mom named my brother, and we came to find out that there's nothing left." And now to have to go and try to get the information from that son that misused the money is virtually impossible. And to try to recoup any of that money it's not going to happen, or it's not going to happen anytime soon. So making sure that the right people are in these roles is crucial. The other reason having the right people in charge is crucial is because, unlike a healthcare proxy that becomes effective at the time you become incapacitated, a power of attorney is, most of them, the way that we draft them today, is they're effective as soon as they're signed. So I could have a power of attorney right now. Well, I do have a power of attorney right now, and they could go out and act on my behalf and make transactions on my behalf, even though I'm fully capable of doing it right now. So you want to make sure that the right person is in place from the beginning, because this is something that springs into action the moment you sign it. So when you're considering who should be my agent, you want someone that is trustworthy, that is organized, because this is a role where that person they'll have to keep a paper trail. They'll have to keep records of everything they're doing. Because if the day comes that they need to account for everything they've done, you want them to be able to back themselves up. Because one thing with a power of attorney, if they have misused your money and they've done the wrong thing, then they could be personally liable for the mistakes that they've made. So any good power of attorney, or any person in this role, should be a good money manager. They should be organized, and they should be able to account for everything they've done. And we know that maybe somebody's good with money, but they're not a tax professional, or they're not a financial advisor, and that's fine. But it's someone that would be able to be resourceful enough to engage with the professionals that they need. So if they need an accountant, or they need to talk to an attorney, that they're resourceful enough to find that person, instead of trying to DIY or figure it out themselves, because that's when things normally start to go south. And definitely someone that's willing to serve, especially depending on how complex your assets are. Sometimes mom and dad just have a house and a bank account and a retirement account to manage. That's very different than mom and dad own multiple income properties or they have a business. To me, that takes a specific person to want to take on that role to manage those assets. Those are two very different situations. So definitely, whoever you have in mind, you should talk to them ahead of time. And also, you should always have a backup because there are situations, especially now. I've had clients that say, listen, it's just me, my mom, and my sister passed away from COVID. So now it's just me and mom. What happens if I die? Who's going to be the backup? You always want to consider a person to step in if your number one person is not available. So one thing to consider is a primary and also a backup when you're making these documents. So the other question that I get a lot is, so what if mom doesn't have a power of attorney? Now what? Now what do we do? Unlike a healthcare proxy where the state comes in and decides if you don't have an agent, the order of priority of people who can make a decision for you, it's not the same for power of attorney. There is no order of priority. What has to happen is someone now has to petition the court to become the guardian. And that's a lengthy process. And it's also, it can become an expensive process, but it is a whole court hearing where evidence is put forth and the court needs to decide who gets to make these decisions on your behalf. And the decision lies with the court, not with your family members. And if there's more than one person that wants to be your guardian, then guess what? There's going to be a fight. I've had many contested guardianship cases that I've been appointed to, and none of it's pretty. None of it's over and done with. They're long, they're lengthy, and they're costly. And oftentimes that money's coming out of your pocket. And it's just an easy thing to circumvent by having these documents ahead of time. So if you lose the capacity to make decisions for yourself and you don't have a power of attorney in place, the solution to that is a guardianship. And guardianship is a major process because it also is stripping someone of all their civil rights. It doesn't just, you're deeming someone incompetent under the law to make decisions for themselves. And that's really not a position that I'd want anyone to be in. So I would definitely say it's important to make sure that you definitely have a power of attorney and a healthcare proxy. The fourth step in this whole process is creating a list of your passwords and digital information. Just like your HIPAA gives your healthcare proxy the access to your health information, we live so much of our life online. So we need to get access to that. And with all the privacy laws that are out there, it's very hard for someone to get access when they're not the account holder. I know here in Virginia, if we need to get into someone's iPhone and they've passed away, we need to go get a court order for that. And that doesn't really help the situation when we need to get in there to access information to pay your mortgage or just to do anything that needs to be done in a pinch. Having to go to court to get a court order to get into your cell phone, that could easily be circumvented. So as you're creating your estate plan, it's a pain to do this, but it is important to make sure that you have an inventory list of what online accounts you have and what are your usernames and the passwords and the security questions, or where do I might have that. How does someone access that? Where are all of the important bits of information that someone needs to get access to? And I wouldn't even limit it to this list. And sometimes people have online businesses. What if I'm an Amazon seller, or I have an eBay store or an Etsy store where I generate income from, and now I'm unable to access that? Well, your power of attorney should know how to get into that, because if they need to use that money to take make sure your bills are paid or you're taken care of, they need access to that. So these are all important details to make sure you check off your list as you're putting together your estate plan to make sure that all bases are covered. All right, we are about at the halfway mark now. We're going to start talking about distributing assets. What happens to my stuff after I pass away? How do I handle all of that? It could be handled a number of ways depending on what you have and how you want to leave it to your family members or your loved ones. But we'll just talk about very basic overview right now. The main vehicles or how you can leave your assets to someone is by either creating a will or a trust. You can provide for your family at your death through either one of these documents. There are some key distinctions between both of them. So a will, if you have a will and you pass away and you say, I want to leave my house to my kids, that doesn't happen automatically. You'd have to go through a court process called probate. And probate is a process where you submit your will to the court and you give notice to all your family members or anyone entitled to something under your will, and they can contest this. And it's through the process that we are able to legally change the title of these assets from your name to your kid's name or whoever you're trying to leave these assets to. It also can be lengthy, it can be costly, and what I've found is depending on the dynamic of your family, sometimes it can create a whole court battle. I was consulting with someone last week and the gentleman said to me, I have all this money, I have 5 kids, none of them get along, and I like one kid, she does all this for me, I want to make sure she's taken care of, but I know they're all going to fight. What do I do? And that's something I hear all the time, and a simple solution to that is to create a trust. A trust has many, many, many purposes. They're flexible to a whole bunch of purposes, but one thing I use them for often is to circumvent probate. If you have a trust and you transfer your assets into trust, the trust is the legal owner of your assets and you are the beneficiary and you get to enjoy those assets. But when you pass away, you name a beneficiary in your trust who those assets will automatically pass to. So you don't have to go through a lengthy court process. You'll save money on the other end. But the one nice thing about that is whoever your beneficiaries are, they only are entitled to know what they're receiving under the trust. So with a probate, your will is public record, but when you have a trust, that's kept private between you and the beneficiaries, and you only know what you're going to receive. No one else will know what everyone else is getting. So it really depends, I would say, on what type of assets you have and what your goals are and how you want to provide for your loved ones after your passing. That will determine what the best thing for you is. And if you don't have a will, the state says that they have their own estate plan for you. Just like the healthcare proxy, they have an order of priority of who can make decisions for you. The state will come in and say, hey, we have an order of priority of who gets your stuff because you didn't take the time to make your own will. We have one for you. And generally the order is your spouse, your children, your parents, your siblings. And the problem that often arises with that is maybe I don't like all my kids the same. Maybe I really don't like my spouse that much. Maybe maybe I don't like my siblings that much. Or the other issue that comes up is what happens when I have a family member that has a disability and now they're going to inherit money. That could affect their government benefits, it can be devastating when someone loses their government benefits. I have a lot of people who inherit money and now they don't have access to long-term care benefits under Medicaid, or their SSI will be affected. Or also, what if I have a child that's has an addiction? I don't want them getting this money and then spending it all. Or what if I hate my son-in-law and now I'm going to give my daughter all this money, and what if they divorce and he ends up with it? So these are a lot of things that I talk with my clients about is I need to know all these details. I need you to tell me everything so we can make a plan that works best for you to make sure that your assets or your money is used the way that you want it to be used. So if you don't have a will, the state will come in and provide their own estate plan for you, and it most likely will be the one that is not your first choice. The sixth part of this, part of the estate planning process, and now this is really important, especially when we're dealing with so many people that are encountering the COVID. So many people are getting sick and having, maybe I unexpectedly am passing away, and now I have all of these assets that I have designated a beneficiary on, and they automatically pass to them. So life insurance accounts, life insurance policies, annuities, retirement accounts, some bank accounts, they pass outside of your will. And on those accounts, you can designate a beneficiary of who you want these accounts to automatically go to. And one thing with these are, if you don't have the right person named as the beneficiary, you can't go back later on after you pass away and correct it. So if you are recently divorced, it's time to update or review your beneficiary designation forms, because maybe you don't want your ex-wife getting your life insurance proceeds. Also, one thing that happens often is the financial institution very often will list the wrong beneficiary. Either they're not spelling things correctly or they completely have it wrong. So it's very important that you go through your beneficiary designation forms every couple years and make sure that everything's right, and that these are going to the right people, and making sure that if mom's on Medicaid, I'm not going to leave my $1 million life insurance policy to her, because that will affect her later on. There's ways to protect these assets to make sure that money gets used for people, but it also doesn't have negative effects on them. So it's important to go through these forms every once in a while, make sure the right people are listed, and if you have to make changes because of something like a government benefit, or maybe there's a child that has creditors or is going through a divorce, making sure that this money that you want to leave to provide for them is not going to be wasted. All right, now we're going to move on to guardians. A lot of people have minor children, anyone under the age of 18. And when you're doing your estate plan, you need to consider, what about my kids, right? I can provide all these assets for them. I can make sure that they have a house to live in, that they have money to pay for their expenses. But who's going to care for them? Who's going to make sure that they're raised and they have all their things provided for them? So just as important as it is to make sure that your will is set up and you have all your beneficiary designation forms lined up, it's also important to name a guardian for your children. And that's something that would be outlined in your will. So if you don't make those decisions, the court will do it for you. And that is usually, again, could be a long drawn out process. You could have multiple people or family members fighting over who wants to be the guardian for your children. And it's something that could be circumvented by making these decisions ahead of time. Now, a court would ultimately have to approve that decision of, can this person that you've decided you want to be the guardian, we have to get them actually qualified as guardian, and can they do that? But it would be very helpful to your children and to your family members if you at least outlined who you had in mind to be the guardian for your children. And when you're doing that, there's a lot of things to consider, and I've included some of them in this presentation. A lot of times people say, "Oh, I'll name my parents as guardians." Well, if your parents are getting ready to retire and you have small children, do they have the longevity to raise your children, right? Or do they have the resources to raise your children? These are things that need to be considered. And also, if there's someone that you wanted to exclude as your child's guardian, someone that you know you definitely don't want to be in charge of raising your child. And as I talked about before, with having a backup healthcare proxy and a backup power of attorney, you definitely need to consider having an alternate guardian. Always having a backup. You never know. We always plan for the worst and hope for the best, and you never know when you're going to need that other person to step in, even if it's just temporarily. But you want to make sure that you're in control of the people that are going to raise your children. So having that alternate is key to this process. If you do name a couple, I think that something that's important to think about is, what happens if this couple divorces or if one spouse passes away? How would that affect my decision to name either one or both of these people as guardian? Maybe one of them is the moneymaker, and if they pass away, how is that going to affect the quality of life for my child? So that's definitely something that needs to be considered. And the other thing to consider is who would be the interim guardian for my children? Because I name a guardian in my will, but this is a process that I need to get approved by a court. So it could take time for this to happen. So is there someone that if I pass away, I want my child to go with immediately, temporarily, until this person gets named? Or what if this person doesn't live in the vicinity, and either they need to make arrangements to come here to be with my child, or I need to make arrangements need to be made to get my child to be with this guardian. So these are all factors that need or should be considered when you are deciding who to name as your child's guardian. You need to think it through of how the logistics of this work to make sure that you have all bases covered. And this is something that I counsel all my clients that have young children, because you don't want to leave. You don't want your kids to be left out of this plan, and it really needs to be. It's devastating as it is to lose a parent, and you want to make sure that this is almost as seamless as possible for your kids. Everyone's going through a devastating time if they've lost their parent. So these are important to consider. And the last step is being proactive. Estate planning by itself is all about being proactive. It's about making a plan of what to do in the case of in the case of an emergency. And as I mentioned before, it's really important to have these are difficult conversations. These are very heavy decisions that you need to make ahead of time, but you need to talk to your family and your loved ones about it ahead of time. The worst thing I think to have happen is that your executor is surprised that their executor or their power of attorney or your healthcare proxy, this is all news to them, that they have been entrusted with these decisions and you have not told them once until the day comes where they have to make these decisions. So I think talking to your family members and your loved ones is important, making sure that they understand what your wishes are and what their role will be ahead of time. So when the day comes and we need to actually put all these things in play, everyone's on the same page. And also one other important reason to talk to your family members ahead of time, I think maybe a little bit of it is depending on the dynamic of your family, but I think if someone's going to get a little more than another person, or you have a specific way that you want to leave your assets or share them with your family, I think it's important to have those conversations ahead of time, because you will possibly prevent a huge court battle after your passing that could deplete your estate. So again, these are very difficult conversations to have up front with people, but these conversations will go a long way later on when we need to execute your plan. And the last thing is scheduling a consultation. Putting this plan together is mostly it's on you, but you do need to find the right attorney to work with you to help walk you through this process. And whether it's me or if it's someone else, I do think that it's important to sit down and schedule a consultation with an attorney that is well versed in estate planning, There's many organizations out there. For instance, the National Academy of Elder Law Attorneys. I'm a member of that organization, and we're a group of attorneys across the country that all we do is specialize in estate planning and elder law. We're very well versed in this area, and surprisingly, this is an area that is just inundated with, there's so many different rules and complex rules that everything affects everything else, and you want to make sure that you have a knowledgeable attorney on your side helping you carefully craft your estate planning documents to make sure that these documents will actually work when you need to use them. And I will add this, if you are considering going online and finding a do-it-yourself will or power of attorney, I will strongly urge you against that. And it's not about me wanting to make money, but I have a number of clients that have brought documents to me that they're completely useless, and they found them online and they've executed them, and they're a New York resident giving me a California power of attorney and it's completely useless, or it's a will that they haven't filled out right and they've left their stuff to no one, and now we have to do an entire probate. So as attractive as it may look to do it yourself online and pay a one-time small fee to get all these documents done, you could be causing yourself more harm than good. So I would urge everyone to think about consulting with an attorney before you do all of this. At the end of our presentation, or I'm sorry, with either tonight or tomorrow, you're going to get an email with the slides and a recording of the presentation. You will also get a link to my calendar. If you'd like to schedule a consultation, you could see my availability. I do not charge for my initial consultations. I believe that estate planning is a very intimate process, and I want to make sure that anyone feels comfortable with me and that we're a good fit for one another before we start walking through this very lengthy estate planning process. So I offer free consultations just so we can get a sense of one another, see what you're looking to do, and see if we're a good fit for one another. So you will get my information, my access to my calendar if you're interested in scheduling a consultation. And I will add that this COVID-19, all these restrictions with social distancing and not being able to meet with people face to face, it has not hindered me from working with any clients and putting together any estate plans with anyone. We're actually allowed to execute documents and notarize documents through video conferencing now. So just like how we're meeting tonight on a webinar, it would be something similar. So you don't have to wait until all these restrictions are lifted and we can meet face to face. We can do it over the webinar. So don't worry about having to wait to do this. So if you want some more information about our firm, you can like us. We're on Facebook, we're on LinkedIn, we're also on Twitter. We post information often. It's a lot of I'm in charge of it, so a lot of it is estate planning and elder law stuff and how it affects our clients. There's always new rules or some new change that affects people and how you can leave your assets, or some decision that you can make for yourself. So that information we post here. But if you wanted to contact us one-on-one, you could feel free to email us at info@monteleonlaw.com. You can find us on the web, or you can give us a call. So if anyone has any questions, oh, I think someone has their hand raised. I'm gonna unmute you. Go ahead, you can ask your question. No? Okay. Nope. I don't know if anyone else can hear. So if anyone else has any questions, now's the time. Feel free to raise your hand and I will unmute you and you can ask a question. And if you don't have any questions, or maybe it's something that you want to ask offline, you could feel free to email me and or call me, and we can discuss whatever your questions are offline. All right, guys, thank you for joining us tonight. Don't forget, you will get a copy of the slides and the recording emailed to you. And It will also have all my contact information to contact me separately if you wanted to schedule a consultation or ask any questions. So thanks so much for joining. We do have 2 other webinars scheduled, one in 2 weeks and another in a month. Our next topic is going to be about what happens if you are named as a power of attorney or a healthcare proxy or an executor under the will. What are you supposed to do? Because there's a lot that goes into those roles. And then our last session in May will be about, towards the end of May, will be about long-term care planning with Medicaid. There was a lot of new rule changes in New York that are going to affect a lot of people come October. So we're having a webinar about all those changes. So I hope to see you guys there, and have a great evening and stay healthy.